Now, Angelika Yates will talk about the double taxation agreement between Australia and Germany, and in particular the concept of what creates a permanent establishment under that agreement and the consequences of operating through a permanent establishment. Angelika is a duly qualified lawyer in Germany as well as Australia. Angelika specializes in cross-border transactions and has over 20 years experience working as a lawyer in Germany, the UK and Australia, including at Addisons Legal, Luther Rechtsanwaltsgesellschaft and Cardos Scanlon. Angelika is now based in Sydney and a solicitor at Addisons, and she was promoted to partner last year. So congratulations, Angelika, and I'll hand over to you.
Yeah, thank you, Claudia. Very good, and welcome to everyone on the conference. Yeah, very happy to have the people from Germany here, which are now, I think, either just waking up or have to go to work already again. So, and in Australia, we're just winding down for the day, and yeah, hopefully I will not take up too much of your time. Just about to share my screen. Hang on. Oh, wrong one, this one. There you go. Okay, I hope that worked. Okay, let's get started. So I'm going to talk about permanent establishment in Australia. I'm not a tax lawyer, I'm just a corporate lawyer, but I quite enjoy tax law as well. And it often sort of becomes relevant when you advise clients on corporate transactions or on their plans of the operations for in Australia. Tax often is an issue. No, I can't. Oh yeah, sorry. When I get back. Oh, yeah. Okay, so the agenda is I first briefly explain the concept of a permanent establishment and how it will be taxed. And then I talk about what creates a PE. And I focus here on the double taxation agreement between Australia and Germany. And there are two different concepts or definitions. One is a general definition, which I will talk about. And then there are some specific scenarios that will always create a PE as a so-called deemed PE. And then, yeah, just summarize these various types again. And hopefully we have time for a few case studies as well. So first, yeah, PE is an important concept of international taxation because it gives a country the right to tax the income generated in that country by a foreign enterprise. So the purpose is to determine the right of a state, the state of source, to tax the profits of an enterprise of another state. So it's a little bit similar to what we talked about, what Chloe talked about with the taxation of multinational companies. But the PE definition, even so it is quite broad, it doesn't capture everything, especially not digital services. And that's why they're now thinking about another way of taxing even digital services. But the PE actually focuses on physical presence. And I'll talk about that later. And there's a fun fact I came across when I did my research. Actually, the PE concept comes from Germany. It was first seen in 1845 in the Prussian Industrial Code. And then there was the first ever tax treaty, interestingly, between Prussia and Saxony in 1869, which also talked about a PE, and it was called a stehendes Gewerbe. Now, actually, the German term for PE is Betriebsstätte. But yeah, and the first general definition of a PE was in the German Double Taxation Act, which had the purpose of preventing double taxation between the German states at that time. So, and from Germany, the PE concept was sort of accepted all around the world, and yeah, now is an important concept in international taxation. Okay, so a PE is a taxable presence that a foreign entity has in another jurisdiction. And yeah, again, it it deals with taxation rights of profits generating in a country by a foreign resident entity. It has to be distinguished between the concept of a legal presence. So often clients ask whether they have to incorporate a subsidiary. And the legal concept under the Corporations Act, when you actually have to incorporate a company or register as a foreign company with ASIC in Australia, it's a completely different test to the taxation rules. So the requirement to register a subsidiary or register as a branch with ASIC occurs much later. So the taxation right comes in earlier, which means even if you don't have a subsidiary and if you don't have a branch, you still might be liable for taxes in Australia if you have a PE. And because the definition of a PE is quite broad, it often happens that a foreign entity unintentionally creates a PE. And that's why even corporate lawyers have to be aware of this concept so that they can advise their clients accordingly. So this is again about the concept. So we have here a German company, and the distinction is either doing business in Australia or doing business with Australia. If you're doing business in Australia with a physical presence, you most likely have to, may create a PE or have to at least look at it a bit more in detail to analyze whether you have a PE or not. Whereas doing business with Australian entities generally will not create a PE if there is no physical presence in Australia. As I said before, every country has developed criteria what will define a PE. I'm talking about, so the OECD has also developed model law on which most double taxation agreements are based. The Australian-German double taxation agreement is also based on the OECD Model Tax Convention. And the test, and the Australian courts have confirmed that the OECD commentary can be used when interpreting the double taxation agreement. And there is actually quite extensive commentary issued by the OECD, which is very helpful when you want to work out what the articles of the double taxation actually mean. And the double taxation agreement between Australia and Germany came, the new one came into force in early, I think, 2016 or late 2015. So quite recently, and it replaced a very old double taxation agreement from 1975. And the new one is actually, was the first modern type double taxation agreement, which was based on the latest OECD Model Tax Convention. So it is a very modern style DTA and has a very broad concept of permanent establishment. So Article 5 has a general definition, and that is, it is a fixed, so first part of it is, it must be a fixed place of business. And then there is some specific definitions, which I'll talk about later, in particular the agency PE, but we come to that a bit later. So now the general definition. It has 3 conditions that must be satisfied. First is a physical place of business, such as premises or machinery or equipment, so something tangible and visible. And then this place of business must be fixed. That means it must have some degree of permanence from a time perspective. And also must be at a distinct place. So it can't be just moving around all the time. And then, as a last conditions, the foreign entity must carry on a business through this fixed place of business. And there are some examples given in Article 5, subsection 2 of the DTA. which is a place of management, which is quite interesting. I talk about that later in more detail. Branch, office, factory, workshop, so the obvious things that you would imagine to be a place of business, right? But also a mine or other place relating to exploration of natural resources, or, and this is unique for, or not unique, but this is not in the OECD model law, but in the Australian-German double taxation agreement, agricultural, pastoral, or forestry property. And I'm sure that was put in there because of Australian requirements. And then there is some exclusions in Article 6, which says that facilities that are used solely for storage, display, or delivery of goods do not normally create a PE. This is something like a warehouse, for example, from which you deliver your products. And yeah, here storage and maintenance of stock of goods solely for the purpose of processing by another entity. So these things are carved out from the definition of a place of business. However, this is only the case as long as the overall activity of is just of a preparatory or auxiliary nature. So if one of these things is actually part of a bigger activity, then again, it would be a permanent establishment. So just some ideas what also could be a place of business. For example, a server storing data for operating a digital business, but the server actually is something tangible. So just the data by itself would not be regarded as a place of business. Machinery, equipment, we already had that before. A pipeline that goes through yeah, different countries. I mean, Australia is just one big country. Operating a taxi, selling goods from a mobile van. The question is it a fixed place of business, or is it because it's moving around? A stall at a trade fair, so just a temporary presence. A fishing vessel, which operates just offshore. And the home office for employees, that sometimes also could be a place of business. So the requirement that actually it must be a fixed place of business. As I said before, there must be a certain period of time, and the rule of thumb is 6 months. But also recurring activities, so on off, may be added up together, so in aggregate, that they could exceed 6 months. And then the foreign entity must have a certain right of use over the fixed place. The wording is it must be at the disposal of the foreign entity. So the foreign entity must have some right to either be there or not be there, or decide when to access it, and must have a right of access at any time it wants, more or less. It doesn't matter whether it's owned or leased. So leased premises, of course, would be a fixed premises as well. There is no formal legal right required. It's a question of fact and degree. And even illegal occupation could constitute a PE. So, and then the last condition is that the entity must be carrying on the business through this fixed place of business. So this is called the business activity test. And yeah, then we have to look at what actually, is there any income generating activity conducted at this fixed place of business? And again, here, mere preparatory or auxiliary activities would not already be regarded as a PE. For example, this is market research, advertising, supplying information about the products without actually entering into any contracts to sell the products, scientific research, and other things that are not generating any income. And now so a PE comes into existence when the foreign entity commences the business activities, and it ceases to exist either when the fixed place of business is vacated or disposed of, or when the entity ceases to carry on business activity through it. And so that is just a summary, just to recap. So a place of business, something tangible, it must be fixed, meaning it must be for a longer period and at the disposal of the foreign company. And then we have the business activity that must be carried out at that place of business. And there I have a question slide, if anybody wants to ask questions now about the general definition, or we have the questions at the end.
Well, I wouldn't mind asking one right now.
Okay, good.
I was just wondering because on the requirements for a PE, and you talked about a warehouse. Did you ever come across the case of a consignation warehouse? Because I saw that with a lot of producing companies. Yeah, where pretty much the producing company stores goods that they don't own but can take up for their
That's a very good question. And the consignment, the consignment warehouse is often discussed when we talk about PEs. I'm just right now not so sure what the answer is. So, but I think consignment warehouse, I think.
But I thought it must be more difficult because it's, the property belongs to another company, but it's on the premises of a company in Australia, and they can, whenever they want, can take it and make it theirs. So
correct. So, but I think because, so as long as let's just say the German company stores their property as consignment goods in a warehouse, and the the Australian distributor or consignee has access to the warehouse to sell the products and then make a revenue out of selling the products. I think in that instance, the German company that still owns the goods but does not really, the revenue is generated by the Australian consignee. So I would think in that case, unless they're related parties, if they're independent, it would not be a PE. Unless, is Jennifer still here? Jennifer?
Yes.
No.
So
yes.
I am here. So I think if it's a consignment agent, no, the answer is no. Are we talking about an agency or?
Yeah, we're talking about the German company storing the goods, owning the goods, and the Australian consignee taking the goods out of the warehouse and selling them. So that would not be a PE of the German company.
Yes, I think that's correct. Yeah.
Yeah, I think that's correct as well. Yeah.
Thank you.
Unless they were related. And so if as long as the Australian company is independent, it's not a PE of the German company.
Yes.
Makes sense. Yeah.
Okay. So now we talk about some scenarios that are actually specifically addressed in the DTA and always will create a PE. So, I mean, the first one is a bit of doesn't really fit here because the place of management is something that is mentioned in Article 5.1 as an example for a place of business, but I put it here because it sort of overlaps with the control and management rules that we had before, and I will talk about them just on one slide. Then there is a deemed PE if you have a construction or installation project or an exploration project, or if you operate substantial equipment. And then the most important one is actually the agency PE, which I will talk about in more detail, and the manufacturing PE. So the place of management, we talked about that before. I think Jennifer talked about that, yes. So there are certain rules which are called the central management and control rules, which I now understand is not that clear and currently being decided on whether it actually should give Australia taxation rights if the management of a German company sits entirely in Australia and makes all relevant decisions about the company, about the German company in Australia. So as I said, place of management is actually mentioned as a possible place of business. The thing is that if you adopt this and would say there was a PE created by having the management in Australia, potentially this would actually apply then to the worldwide income of the German company, because the activity is the control and management, and all income of the German company is sort of sourced through this activity. So that's a bit of a interesting concept. Jennifer, yeah, do you agree that that is sort of an overlap area with the central management and control rules? Yeah.
Yes, currently under the current rules, until the budget announced change come through, that's definitely a risk.
That could be
a bit perverse, but it is the way it works.
And it would be for the worldwide income, I would think, right? Yeah.
Yes, well,
because
I
the
guess
management,
it becomes a tax resident, then yes, that's right,
yes,
worldwide
yes,
income.
Yes, yes. Okay, and now another specific PE is if there's a building site or construction or installation project which lasts for more than 9 months. This is something you have to be aware of if you're a German construction company. If you come to Australia and you agree to do a construction of a building in Australia, here's the example, and the project goes for 12 months, for an example, then any income derived by the German company from the project is subject to Australian income tax, because it's deemed to be a PE. And the same actually applies to consultancy contracts in relation to construction or building sites. And for an example, if a German company enters into a consultancy contract for the fit out of a film studio in Sydney, and the project continues for more than 10 months, any income derived again is subject to Australian income tax. Even so, that from a legal perspective, the German company would not be required to register a branch or set up a subsidiary, but still the taxation rights for this income are with Australia. But this does not apply just to the mere supply of equipment. So if the German company would supply solar panels for the construction of a solar farm in Australia, and the contract does not include the installation, then Australia has no taxation rights in respect to this income. Very similar rules apply to exploration projects. I mean, Australia is a big mining company, so they have thought that they should tax activities carried out by a foreign company in Australia in relation to an exploration project. And here the period of time is even shorter. So we had before construction was a minimum of 9 months, was 9 months. Here it's 90 days in any 12 months period. So even if a German engineering company provides services to a mining project in Australia, for an example, and they'll do this on and off for a total of 100 days in the period from May to October, then any profits again are taxable in Australia. And this and the next deemed PE is operating substantial equipment. So here the time period is 183 days in any 12 months period. So virtually half a year, but it can be scattered throughout the whole year. And the question, of course, is what is substantial equipment? And again, this is a question of fact and degree. There's various tax rulings about this, and they're discussing, for example, computer hardware, which was not found to be substantial enough. But I would think like a large excavator. Okay, this again is also a mining project, maybe a bad example. So let's just say some other large equipment, not mining related, is hired out by a German company, and the company also sends one employee to operate the equipment, and it's used for 200 days throughout a 12-month period. Again, that would be a deemed PE, and any profits derived from that activity would be taxable in Australia. And any questions on these types of PEs? Michael?
Yes, that now concerns me.
Yes.
So the examples, let's say we talk about the substantial equipment, you put in there ignoring the mining for the purpose, but is the hiring out is not enough? You have to provide the operator, because you say in there, I think
there was a change. Funnily, in the old DTA, it was just the hiring out. It was just maintaining substantial equipment, or just having it here. But the wording of the new DTA actually says specifically operating. That's why I think it must not just be hired out, but also operated by somebody. But I'm not sure. Jennifer, do you know what the operating really means physically, having somebody here in charge operating it?
I'm not sure of the extent of that.
Yeah, so maybe Michael, I have to look at the OECD commentary to see whether it's actually whether some form of operation must be involved there as well. Whether
but,
it's just
with all three examples that you named, the construction, the mining, and the substantial equipment. Let's say for instance, if you go to the one before the one with the construction.
The construction? Yeah.
Okay. Yeah. So the first point enters into a construction contract. I mean, what does your role have to be in the construction? Do you have to be the general contractor, or if you are providing part of the service? You know, I mean, say for instance, I acted for a company that did the roof of the large roof on a shopping center in Melbourne. But I don't think that they built I mean, it was a huge construction, but I think they put in just a roof. Yeah, is that?
Yeah. So did they put on the roof with engaging subcontractors in Australia, or did they send their own people out here to do it?
Well, they most certainly had a project manager they sent out here, and they had hired Australian project managers to assist, but the actual work was done by an Australian construction company. Yeah,
but it says here also, if you look here, carrying on supervisory or consultancy activities in connection with a building site or a construction or installation project. So that is even if they just were supervising it, right? It would already be a deemed PE. If it was for more than 9 months, maybe it wasn't for not more than 9 months.
That was such a big project. It was, I guess, but yeah, because see, I know I dealt once with a German company that does what is it, a flat glass manufacturing equipment, which is basically like long conveyor belts. And when they are constructed, they send one person out to supervise, but everything else is done by Australians. And I would just be interested, you know, I have no idea how this is 15 years ago anyway.
So there is,
but
yeah, so that is exactly right. So because this is such a gray area, so it's always, as I said before, a question of fact and degree. So there is no clear hard and fast rule. What I mean, it gets a bit clearer here with the specific PEs than with a general concept, but even here, I think it's still sometimes a question of, yeah, many factual things. And that's why there is really quite a large, huge amount of tax rulings out there that you can look at, where people actually wanted to do a project and they asked for a tax ruling and asked, do we create a PE if we do this or not? And you almost will find a good one that fits your situation. But then again, this new DTA between Germany and Australia is quite different from the others. So if you have a tax ruling for a Singapore company or whatever country, it will be different under the German-Australian DTA. So the best source to look at really is the commentary, the OECD commentary, because they have good examples in there as well. But then again, the Australian-German DTA is even slightly different from the OECD model as well. So it's not that easy. So Jennifer, do you normally ask for tax rulings, or what do you do?
Yes, I think if it's borderline, in which the example that Michael has described, it sounds borderline. So it would be prudent to go for a tax ruling.
Yeah, and what is your experience? How long do they take to come back with a decision? I have never actually asked for one.
Now, during COVID, I haven't actually applied for one during COVID, but I've heard that they are being quite slow because of the redeployment to other areas. But normally, you know, they're not that you know, they'll come back to you within one or two sort of months.
Yes.
Yeah, I mean, they do have a requirement to get back to you in 4 weeks, I think, is their kind of general requirement.
Yeah. I think the sort of PE tax rulings, as I said, I think there's a lot out there. Is that also what you think? Is that a fair?
Yes, and because they are so fact-based, you can sort of you can never really find one that's exactly
not exactly
within what
same.
You're doing, but yes, there are a lot. You can see a lot of guidance to see which way they're going to go.
Yes, to get a feeling for it. I think it's all about to get a feeling for it.
Yes,
yeah.
yes.
So
and
yes.
Could you help, or would it help if you structure a project in such a way that you have different phases, and then you make sure that each phase does not run over the 9 months, or is that too shaky? And
yeah, I think there would be some sort of anti-avoidance concept there. It can't be too obvious. So
but maybe like with the roof that Micha had, I mean, maybe you do have, I don't know, a certain lower roof, and then a couple of months later only the upper roof can be installed or whatever. I mean, not meaning to to boldly avoid anything, but just maybe there are natural steps, and then one should make sure that that's structured like that.
I would think if I look at this, you know, and you know, if you look at, let's not call it avoidance, but structuring. I mean, see, for instance, the structuring. You know, for example, if I look at this thing with the operating of the substantial equipment, I mean, obviously, I could have a contract with one entity for providing the equipment, and a different entity would provide the operator. You know, this.
Yeah, if they are related companies, there are some. They're called anti-fragmentation rules. So if you artificially fit the various things between the separate entities within the same group, they would see it as being provided by one entity.
Yeah, no, I look at, I understand, but say, for instance, one of my mining clients, they not in this context, because that was done through an Australian subsidiary anyway, so that was not really the point there. But they hired out mining equipment only with operators because of damage to the equipment. But one of the results was always that the mining companies are such cowboys that they destroy very expensive equipment. But the operators were not necessarily our employees. They were just people that, you know, contractors that were employed for.
Yeah, but I think that doesn't really matter if under your agreement with the client or the customer, if you provide the services of operating it, even if you subcontract it out.
I agree. If it's purely subcontracted out, then it doesn't matter. But if you know, I mean, from a structure point, that would be relatively easy to have a contract where you say, well, you know, you can only, the operators of this equipment have to be approved by us, but they're not actually provided by us.
Yes.
So
that's why it's important, to know whether the operating, what that actually means.
I think that's where we started. Yeah, you two, may I just suggest that we continue with the presentation, because we're almost at the at the end of our time, and then have some more time for further questions.
Okay, now we can maybe talk about it later, Michael. Okay, so there is this. The next one is an agency, the agency PE, which is the very that's, I think, one of the ones that happens most often. And this occurs if a foreign entity engages a person to act in the state of source here in Australia on behalf of the foreign entity, and the agent is physically present in the state of source. And then the agent must habitually conclude contracts or play the principal role leading to the conclusion of contracts. So that is a very broad concept, which was introduced in the new double taxation agreement. In the old one, it was much narrower, that actually the agent must have had the authority to enter into contracts. So they have changed that to playing the principal role leading to the conclusion of contracts. And the contract must be in the name of the foreign entity. It must be for the transfer of ownership or in property owned, so for the sale of goods or renting of goods, or for the provision of services by the foreign entity. And if all these conditions are met, then the foreign entity is deemed to have a PE in the state of source. And this, because it's a deemed PE, it replaces the requirement for a fixed place of business. And for an example, a German company engages an Australian-based employee in a sales function, and then they enter into customer contracts in Australia. So this is actually quite a typical scenario as well that we come across quite often, that German companies that want to get into the Australian market, they don't want to set up a subsidiary. They think initially we just send one of our employees to Australia to visit a few potential customers and see how good the business is. But actually by doing that, they are already creating a permanent establishment, which they're often not aware of. And okay, there are some exceptions. The agency PE does not exist if the agent is independent and acts for the foreign entity in the ordinary course of its business, or if the activities of a dependent agent are only preparatory or auxiliary. So this means if I send my own employee, I'm always dependent, right? But if I send the employee only to do market studies, just have talks to potential customers, but not enter into any customer contracts or negotiate any terms with them, then it is just preparatory or auxiliary. And so that's the way to maybe what you have to keep in mind when you want to do this as a German company. So that's why, so mitigating, you can mitigate the risk of an agency PE by entering into an independent contractor agreement. So sometimes, but you have to be very well aware of the fact that if the independent contractor acts almost exclusively on behalf of one entity, then it will not be independent. So it's a bit the same rules that you have with a deemed employee. So if the German company just says, okay, I want to explore the Australian market, I have a person identified that I think would be a great person to do this for me, but rather than employing them, I enter into an independent contractor agreement with them. And then you have, but if I'm the only one that they're doing the work for, if they're not doing any other similar work for other entities, then this will not be regarded as an independent agent. So what you need is legal and economic independence. So you can't give them detailed instructions or control them. They can be responsible for the result, but they're not controlled as to how they get there. And they must have a number of principles and not just working just solely for one entity. And the other idea was to limit the authority of the agent. So before the new DTA came in, clients were often saying, okay, then we just make it clear in the contract that they're not authorized to sign any contracts on our behalf. But this no longer works because the new concept is much broader, as I said before, habitually playing principal role leading to conclusion of contract. So that's a much broader test. Therefore, it's now really very critical to make sure when you have any plans of sending one of your employees or engaging somebody in Australia to actually enter into customer contracts, that you most likely will have a PE. Here's just the flow chart. I don't have to talk you through this, but this might be helpful when you want to look at this after the presentation. So very similar to the concept of the agency PE is the manufacturing PE. Here again, the German company must engage a person, agent, to act in the state of source on behalf of the entity, but this time it's not for the purpose of entering into agreements, but for the purpose of manufacturing goods for an entity. This happens much less between Australia and Germany. I can't see any German company doing a manufacturing PE in Australia. That's I haven't come across it in my practice anyway. But nevertheless, it's in the DTA. Again, there's a flow chart just to point that out. And any questions on the agency PE?
No questions. I would just like to say, I'm not sure, but I think the last car producer was shut down in Australia a couple of years ago, one or 2 years ago, I think in Melbourne it was. Yeah, I mean, that was probably an industry where certain deliveries or supplies were required, but I don't think there are any bigger manufacturing businesses in Australia. It's very focused on education, services, mining, of course, is still around. Correct. But I think other manufacturing is not so much happening there anymore.
I actually had a client who was based in the situation, but it wasn't a PE problem because they'd done it through the Australian subsidiary. But there was German products that came to Australia, and they were maybe you could say semi-assembled. They were still finalized here, the products, because they were done on they were customized basically for so there was a manufacturing process of goods that are actually, let's say, 80% produced in Germany and then finalized here. It was just done through a subsidiary, so the agency issue did not arise in this, but otherwise yeah. But it was not I think overall I have 2 German clients who actually manufacture in Australia.
Okay. That's interesting.
Everybody else is a distributor. Yeah.
Yeah, exactly.
So it still
Yeah.
exists. Very good.
Yeah.
Are there any
Still
other
exists.
questions? No, I don't think so. Do you still have some more on your presentation, Angelika?
I just have here a beautiful summary
All right.
of all the
Good.
So that's, I think, something again that you maybe want to have a look at later. I
Mm.
don't have to repeat all the
Yeah.
various types right now. But I have some case studies, maybe. We quickly want to talk about those.
Yeah, maybe do one and then we see how
Yeah,
far
then
we
if
got.
we do one, I do this one, the stranded employee,
Oh,
because
sounds
it
good.
has a COVID aspect to it, right? So here a German company recruited an Australian resident employee, let's say in January, before we knew about COVID coming, for a sales role. And the employee was to commence work in April 2020 in Munich. So they signed the contracts, and then COVID happened, and the employee could not travel to Germany because of travel restrictions. And then they decided, okay, instead of coming to Germany, why don't you just work from home in Australia? You can have Zoom meetings with potential customers for us, not just in Australia, but you can meet with people in Europe and sell our products. And then this is what happened. The employee then had good customer relationships and negotiated and concluded some contracts on behalf of Australia, or of the Australian, of the German company, from his home office in Sydney, with customers based in and outside of Australia. So the activity took place in Australia in the home office of this employee. The question is, does this mean now that the sales activities constitute a PE, an agency PE, with the consequence that the profits, the income generated from these contracts are actually taxable in Australia? So generally, yes, because the activity took place in Australia, and that creates a PE, and then we have the tax consequences. But however, let's go down to the based on so there has been recent OECD guidance, and the ATO has released here. Sorry, so the ATO has released guidance stating that the effect of COVID-19 will not in itself result in a foreign company having a PE in Australia if all of the following conditions are satisfied. The first one is that the foreign company did not have a PE in Australia before the effects of COVID-19. So that's a tick here. There are no other changes in the foreign company's circumstances. Again, that's satisfied. And the unplanned presence of the employee of the foreign company in Australia is short-term, is a short-term result of the COVID travel restrictions. So all three conditions are satisfied, which would mean that a PE is actually not created. I mean, but the way this is actually implemented is the ATO will just not apply resources to identify such cases and ask for compliance. So it's more or less no action message from the ATO, because we can't change the DTA, right? So the facts still fit under the DTA, but the ATO has said we will not enforce this. But they will also continue to monitor the evolving effects and give further guidance, if there are other developments. So that's the case study. Any questions on that?
Just a quick comment. I think the third point might be difficult to establish. I mean, perhaps in some cases it's not too easy to say whether the presence of the employee was planned or unplanned.
Yes, that's a good point. I think what is very important here, that you document this very properly, that you have decisions at board level. You say, okay, due to COVID-19, we now have this person working from Australia, but as soon as the travel restrictions are lifted, we will of course transfer him to Germany as soon as he and his family are ready to travel, because I mean, it's not just, I mean, they could maybe even travel, right? But you don't want to expose them to a higher risk of infection by moving them from Australia to Germany.
Yeah, yeah, that's right.
As well. It's a bit safer in Australia at the moment.
It seems to be.
Yes. So I think the main thing is here to document this properly internally so that you can actually always prove to the ATO it was really just because of COVID.
Yeah. Okay, well, I think we've got a minute or two left for any other questions.
Yes,
I just have a sorry. I just have a comment on this. Outside COVID, we had a relatively similar situation, and I actually never really thought about this in the context of PE. But we had an employee of an American company who was supposed to take over a sales role in Australia. And because of problems with the visa, which really delayed incredibly, she started to work out of, I think, Singapore.
Oh.
And you know, it wasn't my job to look into that. But you know, if I read this, and I have no idea about the Singapore DTA, but if I find myself creating that way, let's say a PE in Singapore, when I want to send an American to Australia, and she's just, and I think the only reason why she went to Singapore was that the time zone was a bit nicer and it wasn't a problem to work from there. But I would have never thought about this in the context that I create a PE in Singapore.
Yes, yes. Yeah, good point.
But that is a typical issue companies have. So when I was working for a Japanese company in Germany, they partly had to establish proper companies in certain countries because of one employee that was doing marketing and sales activities there.
Yeah. Mm.
So that's really a very, very typical issue you encounter, especially, I guess, in Europe, because countries are so close. And then you think, oh, let's do this in Poland and have this Polish person, sell our products. That immediately brings you into that situation. And of course, there's still a difference between having a tax-wise permanent establishment. And now I'm really on ice here because, again, I'm also not a tax lawyer. But there's a difference between having the Betriebsstätte, which is the tax permanent establishment, and then taking the next step saying, okay, we have to, or it's better to actually set up a company there or make it more official, or in certain countries you do have to register a branch office, so I'm not aware when it makes sense to transfer to that next step, but usually one employee is sufficient to get the whole thing started.
Mm-hmm.
Yes. That's right.
So do we have any more questions? Because we're at the end of our time. And of course, I always enjoy talking with you tremendously, especially over all these distances. But do also our attendees have any questions or would like to comment on our conference? Of course, we're happy if you enjoyed it, if you so happy to hear from you.
Mm-hmm.
Thank you very, very much for making this conference possible under these circumstances we are in, and most likely stay with it for a couple of months to go. Even me, in the end, could enter into this conference after 10 minutes or so. And I very much enjoyed the presentations, I have to admit. The last one is extremely important to our company, which is in the machinery business, and we are currently setting up a dam in Australia, which which causes, as it seems, some us being an Australian company.
Yes, or at least you have a PE. I mean, you can be a PE. It's not something that must be avoided at all costs, because you just have to be aware that you have a PE, and you have to do your tax compliance accordingly.